All right, welcome everybody. How many of you would like to know how to properly represent yourself or negotiate on your behalf if you're having problems at work or been wrongfully fired? Raise your hand. That's right. I know you're probably in a room by yourself or your kids are running around or your cat's at your feet, but you can still raise your hand if you want. How many of you would like to be able to help a friend or a family member if they found themselves with a problem at work or wrongfully terminated? Yeah, I think most of us would. Well, let me congratulate you on being here because you've taken the time to answer some of those questions. The folks that really I'm concerned about are the ones who, for whatever reason, don't take this time to educate themselves. What I'd like to do, and then I'm going to dive in some of the three critical mistakes that people make when they find themselves in trouble at work or wrongfully terminated, is tell you just a little bit about myself. Assume that's all right. We are not having a room of people to talk to, but welcome to COVID times. As you know, my name is Tom Spiegel. I've been practicing law for 20 years. Early in my career, started working for employers, so I know how the other side thinks. I spent years as a federal prosecutor where I prosecuted all kinds of serious criminal cases. So I have seen how a case can be put together and go all the way through successfully. I've also seen how cases can fall apart. And what I want is for you to have the tools to set yourself up in the beginning. I don't expect you to be your own lawyer, but to have a strong foundation, to do the right things, to avoid some of the early mistakes that people make when they find themselves in trouble at work. And even more important than that, or just as important, is giving you the power to take control over your own life. And what I'd like to do is tell you a quick example of what I mean by that. We had a woman come into our office a number of years ago. She was a high-level executive at a university, and she was actually in the fundraising. And she'd been there for a number of years. She was knocking the top out of it. She was making that university money hand over fist. But then she did something. Yeah, she did something. She had a baby. She had a baby. And she had the temerity to take some time off and to be with her child, not only to have the child, but be with her new baby. And then when she came back, oddly, the same things that she was doing before that were bringing her great success and high reviews for a number of years just weren't working for her boss anymore. And he was writing her up. He was nitpicking things that she was doing. And she saw the writing on the wall that he was trying to drum her out of her job. For whatever reason, he didn't think that she could continue to perform because she had a young child at home. And when she came to see us and she sat in the chair in front of me, I don't know if you've ever seen somebody that was just so completely beat down that they couldn't take it anymore. It'd been, like water on a rock, wearing her down, wearing her down, wearing her down. Well, that's what she was like. I mean, she was listless. There was no light in her eyes. And you could tell she's usually that kind of person. She's usually pretty vivacious. She usually knows, she's a high level performer, where she was not on that game anymore. She was kind of sitting back in her seat. She wasn't making really good eye contact with me. Fortunately, this story has a good ending because we were able to help her to contact the university to explain where we believe they were violating the law. She was able to get a severance and move on to spend some time with her child, move on, got another job, did, if not just as well, then better. But one of the most gratifying things to see was when she came into my office, after the case was resolved, to pick up her file, and she was just a different person. The light was back in her eyes. She even smiled. It was just, she looked like somebody who'd been let out of prison. And that's what I want for you. If you are facing that kind of problem, if you're feeling beat down, is to give you the tools to get yourself into a better place. Because I think, all of us here have spent a lot of time investing in their career, right? You spent probably years in school. You probably spent years training yourself in the job, whatever it may be. No telling how much money you've spent on it. $10,000, $20,000. I mean, if you're like me, we got to go by higher multiples, $50,000, $100,000. If we take the money that you put into preparing yourself for your career, the opportunity cost that it took you to, when you weren't doing something else in order to get yourself trained in whatever job that you might have, you spent a lot of money, a lot of time, a lot of your life invested in this, and you deserve better treatment. So let's get to the first critical mistake that people make early in this kind of process that can get them in trouble. You probably have you've either seen the old time movies, or you've seen depictions of the old time movies where there's kind of the black and white ones, the silent films, where there's somebody in distress. I mean, we're talking 100 years ago, so they were usually pretty sexist. It was usually the damsel in distress, tied up by the bomb, the round black bomb with a fuse, and the fuse is lit and it's coming closer and closer. And somebody comes in, and the hero saves the day and whisks the person, the damsel in distress, out of danger. Well, there's a similar phenomenon in employment, but the insidious, the really tricky thing is that bomb is invisible. Most of the time, you don't even know it's there. And that bomb is something called a statute of limitations. And what that means is there's a period after which you cannot bring your case. You no longer have a case because you've gone beyond that statute of limitations. And in employment law, there are a bunch of them, but probably a key one for most cases, most discrimination cases, is called, you have, depending on the state, you have either 100 days or 300 days to file what's called a charge of discrimination with the Equal Employment Opportunity Commission. This is not particularly hard to do. We do this all the time for our clients. You don't need an attorney to do it. But if you have one of these cases, like the examples that I just told you of that woman, like that was a discrimination case. That was one of her claims. So if she had gone beyond that 100 days, and in the DMV, which is where I practice, most of the timeframes are 300 days. If you go beyond that by even 1 day, then you've lost your claim forever. I don't care how strong it is. And who knows that statute of limitations? Like, who knows where that bomb is? Your employer. Your employer's talking to a lawyer, more than likely. Your employer's got HR who's telling them about these things. It's often the people like you who are facing a problem at work, who've been wrongfully terminated, who often don't know it. They don't know the bomb is there. So the first thing is find out what that is and make sure you don't run afoul of that. Make sure you either hire an attorney or you on your own file a charge with the EEOC. Or, I mean, it's not just in discrimination claims. All cases have statute of limitations. If you have a whistleblower claim, depending on where you are and what the claim is, it can be as short as 10 days. It can be as long as 30 days or 180 days. It really depends on what the claim is. If you have a wage claim, well, then you've got a little bit more time. You've got 2 years under most statutes, sometimes more. So the first thing is to figure out what that statute of limitation is for you. And you may have multiple, you may have more than one claim for a statute of limitation, is to get a sense of what that is and know what that bright line is so you don't run over it. Because let me give you another quick story, true example. So we had somebody come to our office recently. She was a high-level executive working for nonprofits, and she was she had her baby by this point, but this is what had happened. She was switching jobs. She was interviewing for executive level position at some nonprofits, 7 months pregnant. This was early COVID times, and where everybody was still trying to figure things out. And so she had two companies, two nonprofits that she was in interviews with. She's a very high performer, and they were both showing interest. And the one that she really wanted, they had a number of phone interviews. Obviously, these are normally pre-COVID have been in the office, but they were by phone at this time. And they were going to have a final round of video, right, of video interviews. And they had the interview for her, but because this is before everybody was an expert at Zoom and the various video programs, the audio worked on it, but the video didn't. So they decided to go through with the interview, which went great, went swimmingly. And so she had the interview with a number of the leadership team, and the HR director called her afterwards and told her how great it had gone, and said that she wanted to make her a conditional offer because things had gone so well. She said, normally we'd want to meet face to face, but this process has gone on for so long. We don't want somebody else to snap you up. We're going to make you a conditional offer, but we do want to have a video interview. The senior VP that you'll be reporting to wants to see you, wants to actually see you face to face, even if it's by video. Fine, no problem. So they schedule another one. They start the video, it works on this call, and she notices in the frame that the chair that she's sitting in is too low, so she's like down here. So she asked him, do you mind if I just really quickly grab another chair? No problem. So she stands up, right? She stands up to get the other chair, and what do they see? Well, she's visibly pregnant. I mean, not only can they see it, but she's not as agile as she was before she was pregnant. She had a little trouble moving around. She pulls the chair over and she sits back down and continues with the interview, but she notices a complete change in the tone in the room. The senior VP that you would be reporting to if you got the job, I mean, his body language was like, I am just not having this, right? I mean, he's leaning back, he barely spoke, he'd occasionally nod his head. And she could also see the HR director who was in on the interview have a look of concern on her face. I think not so much because of the pregnancy, but she was reading the body language too about the senior VP. So you can see where this is going. So after this, the director of HR calls her and she says, it breaks my heart to have to tell you this, but we've had in between the time, we made the conditional offer and now we've had some budgetary changes, and we're not going to move forward with this. We're not going to have to withdraw our conditional offer. Well, she is just, talk about your right hook to the chin. She just, what do you do with this? What is she going to say? And not only, not only is it tragic that she has lost this opportunity, which by the way is, we all know that's a lie, right? I mean, they made up the thing about the budgetary constraints. He just didn't like the fact that she was pregnant. That's blatantly illegal. So she had a very, very strong case, but she also loses the other offer because she turned it down. When she got the conditional offer, she turns the other one down. Now, before she comes to see us, this was, some months later, she doesn't know what to do. So she calls her cousin, who's a real estate lawyer out in Las Vegas. Very good real estate lawyer. If I had property in Las Vegas, this is the guy I'd go see. But he doesn't do employment law. And so what he tells her, he doesn't know about the invisible bombs because this isn't the area that he practices in. She doesn't know about the invisible bombs because this is not what she does. She is an expert in her, in her nonprofit world, but she doesn't do employment law. So she doesn't know about the invisible bombs. So what he tells her is, look, you're pregnant, you're about to have a child, just, take some time, let the baby get here, regroup, and then, you can think about what next steps are. So that's what she does. She has the baby, everything's fine, baby's healthy. And she later, after she kind of gets, everything kind of back in order, she does get another job, paying less than what she would have been making, but she comes to our office on day 390 from the time that offer had been rescinded. Well, she was in a state that had a 300-day statute of limitations for discrimination claims like this one. She's out of luck. We had to tell her, there's nothing that you can do. You're out of luck. Your case is really, really strong. There's a lot we could have done had you come in even on day 299, which would have been a little tight. We could have done something, but now you're out of luck. So I don't want that to happen to you guys. So number one, know where the invisible bombs are, know what your statute of limitations are. Number two, knowing what the ask is, okay? So I think many people intuitively know something has gone wrong at your job, right? I mean, you were there, you lived it. Like in both of these examples that I just talked to you about, they came to see a lawyer because they knew that it wasn't right what had happened to them at their job. The trickier part is knowing what the ask is. If you're going to come to your employer yourself, or even if you're going to work with a lawyer, is you have to begin with the end in mind, right? because that's what's going to happen with your employer if they're doing the right thing. And I mean, the strategically right thing. They're going to rely on their lawyer, and their lawyer is going to tell them, well, okay, well, let's think about what our exposure is. What's the worst thing that could happen, assuming, because they're probably going to contest what you say, but assuming that what our former or our current employee says is true, what's there, right? Are we going to have to write a check? Are we going to get sued? What's the end here? On the employee side, it can be more difficult, not impossible, but more difficult to figure that out. And it's often not, because people are so close to it and they're so emotional about it. That's not where they start. They start with something went wrong and something needs to be done about it, which is a logical place. But you need to know what your ask is. If you're going to sit down with your employer, and if you're going to, you may not be demanding, but it is called a demand. What are you going to ask for them to do? In many cases, not all, but in many cases, it's money, right? You're asking for a severance, separation agreement. You're asking for a resolution of a lawsuit, which involves the payment of money. Well, what is that gonna be, right? So you need to know what your possible damages are. What could you, if you went all the way through the process, rung the bell, what is the best that you could get? As you might have guessed, I've got a story for everything, and I got one here too. Early in my career, I worked with a sales executive, and he, doing well at his job. He'd been with his company for a number of years. Kind of not the best relationship with his boss or whatever. He was hitting all his metrics. He was doing what he needed to do. Well, his mother got cancer, serious cancer, and he was the one responsible for her care, and he needed to take some time off. She was in another state to meet with her doctors. We got some questions, so just so you know, I will be turning those at the end. But he wants to go meet with her doctors, and he puts in for family medical leave, which is entirely appropriate. He was entitled to it. I mean, he'd been at his job for more than a year. He worked full time. All the boxes were checked, right? The company had more than 50 employees. He was entitled to his FMLA leave. And this happened really suddenly with his mother. It would just, and I'm no doctor, but whatever. It came on suddenly. He needed to care for her quickly, so he was limited in the notice that he could give his boss. But it wasn't like he was it wasn't like, I mean, he was a sales rep. He wasn't in such an important position that the company's going to tank if he walks away, for a couple of weeks. So he calls his boss. He says, "This has happened to my mother. It's a bit of an emergency situation. I need to go down, meet with their doctors, and get her taken care of." And he leaves a message. He was not able to speak to a supervisor, hangs up the phone, jumps in the car, puts in the paperwork, right? He calls HR, and they're like, "You fill out those," puts in his paperwork, goes down to meet his mother. And of course, there are problems with the paperwork, right? Like well, we didn't receive that form. Well, we need to get some information from you, but he's doing everything that he needs to do. And then he comes back to work. I think he took 2 or 3 weeks off. He comes back to work, and he walks in, pre-COVID times when we walked into an office, but he walks in, and the person at the front desk is like, kind of gives him a look and is like, you need to go see HR. And I was like, okay, that's kind of weird, but I'll go see HR. And he goes to HR, and they say, you need to leave the building because we're terminating you. Your supervisor is saying that you are a no call, no show. Basically, you just didn't show up, and so we're firing you. You need to get off the premises. And he's like, "That's not true. I got the phone records to prove it. I've been doing this paperwork." It was a third-party company he was working with, so it wasn't directly this HR company. As is true in many FMLA circumstances, there's another company that administers it. But in any event, he's got the phone records where he calls his supervisor and tells him, that he's taken time off. So this is just flat wrong. And he's angry. Of course, he's angry, and he's a relatively high earner, and so he's out of work, and he's this is again early in my career, and he comes to me and he's like, "Okay, we need to, I want to bring an action to my company, and I'm, we're writing a letter and all this, and he says, I want to, I want to put in, we're coming down to what's the ask? What's the ask? He's like, I want to ask for, forget what it was, like $800,000. Well, even under the most generous, because he was able to get another job after he was fired. I won't get into the damages, full damages analysis here, but the short of it is, like, even he went to court and knocked the top out of it, he's not getting even close to $800,000. That's just not in the cards for this kind of claim and for the facts of his case. Well, I was young, and it's like, well, that's what he wants to ask for. I'm going to put that number in there. Well, we get a response back from the company, and that lawyer is basically, I mean, he just made me look dumb. And frankly, at the time, I didn't know. I knew that he was not going to get $800,000, but I didn't know how this kind of dance worked. And that lawyer's like, look, this is not even a reasonable ask. I'm always happy to talk to people and negotiate when we think that the company, always happy to do that. But you're so out of the ballpark. Like, come back to me when you guys can be serious. I mean, you talk about having egg on our face and the credibility that we had lost. I mean, we ultimately were able to settle that case, but it took a lot more pushing and a lot more coming back at them than it would have had we had the correct ask up front. Because you've got somebody on the other side who, not always, I mean, companies can mess things up too, but they know the law. They're looking at it dispassionately, and they're like, okay, they're going to make an ask, is it reasonable? Is it somewhere that we want to be? Can we meet in the middle? And if you're, if they're here, and you're way over here, it's just, they're not even going to play the game. So that's the second big mistake that people make, is they don't start with the end in mind. They don't have an idea of what their appropriate asks should be. And the third, so we got the invisible bombs, the statute of limitations, knowing what your ask is, beginning with the end in mind. And third is knowing the process. Okay. I don't think anybody, even when you're negotiating on your own, nobody's expecting you to be an attorney. And in fact, if you're dealing with HR and some people on the other side, they may not know the process, but when you get further into it, it's important that you have some idea of what the steps are and how far along you're willing to push in that process to get what you want. Because there are, these cases, they don't always follow the exact same pattern, but many of them do. There's some kind of engagement with the company. There's some kind of letter or some kind of conversation with the company, either with you or through an attorney, where you tell them, hey, company, this is what happened. This is what went wrong. And this is what our ask is. And then there's there can be, sometimes a company will tell you to pound sand, but there is some negotiation, some talking that happens. And as that is moving along, there are different stages in the process where there are opportunities to put the screws to the company to get to get an opportunity to a window where this case can be resolved. For instance, we talked earlier about filing at the EEOC. So perhaps you contact the company, not getting resolved, you got to file at the EEOC. Well, one thing you want to understand is, how big of a deal is that for the company, right? Like, how much are you really putting the screws to them? Filing with the EEOC, if you have that kind of claim, could be absolutely necessary. So it's maybe something that you may have to do, as we talked about before. It's one of those invisible bombs that you got to defuse. It may be something that you have to do no matter what, but it's also an opportunity to show to the other side, hey, we know what we're doing, and it's, you're kind of up in the, you're showing we're taking the steps to keep engaged here. And also at the EEOC, there's an opportunity for mediation, right, where you sit down with the other side face to face, and it's a good opportunity to resolve cases because you got everybody at the table. So when you're thinking about what your ask is, you have to have in your mind is, how far am I willing to go with this? How far am I willing to, if you're kind of playing poker, right? Kind of the same idea, like, how far, given my hand, am I willing to keep pushing this? Am I going to ante up or not? And so you got to know the steps. So is it filing at the EEOC? Well, okay, you filed at the EEOC. Well, what about mediation? Okay, and now mediation, if that doesn't work, well, then what's the next step after that? Is it filing in court? Well, what does filing in court look like? Which court? What happens after you file in court? These are all important things to know along the way. And each stage, you're sort of up in the stakes for both sides, for both you and the employer. But these, the more you up the stakes, the more you give the opportunity for the other side to blink. And let's face it, the employer, oftentimes they don't want to litigate this either. They've got other things that they want to do. They've got their own expense, and you got to have some idea of what that timeline looks like and what the various nodes are for you to resolve the case, and when you're willing to walk away. Right? It's the Kenny Rogers, know when to hold them, know when to fold them thing, right? Like, should you play your best hand at the EEOC mediation? Should you play it? Should you file in court? After you file in court, should you play your best hand? Did you just stay in through paper discovery? How about depositions? How about pushing it to trial? And all along the way, you have to think about your own time and your own cost, like how there's an opportunity cost for pursuing this. There's a timeline for this. Some of these stages take longer than others, and again, you don't have to have this mapped out all up front, but it helps to have some sense of, this is my ask, and this is sort of in my mind how I'm thinking about playing this out, and whether I'm willing to push this all the way or not. Is there a point at which I'm going to say, this is good enough? Maybe they're offering you something that's not 100% of what you want, but maybe a 60%, and maybe you're at a time, place in that case where it makes sense, because there's going to be diminishing returns from this point forward. You've got 60% of what you want. You might be able to get 100%, but it's going to take you another year and hours of your time, and potentially, if you're paying an attorney tens of thousands of dollars to get there. That may be worth it, but you've got to make that decision. So those are the three things that you now know, right? You got to watch out for the invisible bombs, the statute limitations. You got to begin with the end in mind and have some sense of what your ask is before you show up at the table. And three, you've got to have some sense of what the process is and a sense of how far you're willing to push to get to the number or the resolution that you want. And it doesn't always have to be monetary. I mean, there are non-competes. There are some things that are unrelated to money that you can ask for.